Welcome to the AI for Interior Designers podcast, where creativity meets cutting edge technology. In each episode, we dive deep into the world of artificial intelligence and explore how it's revolutionizing the interior design industry. From AI-powered design tools to the latest trends and innovations, we've got you covered. So plug in, relax, and let's embark on this exciting journey together. Welcome to AI for Interior Designers podcast. P.S. This intro was written by and voiced by AI to sound like your host, Jenna Goodusek.
Hey designers, welcome back for episode 37 of the AI for Interior Designers podcast. I'm your host, Jenna Goodusek, and Happy New Year. This is the first of the New Year podcast episodes. We'll say this is season 2. I don't know. Took a nice little break and disassociated from the world over holiday, and back feeling refreshed and planned and ready, and got some stuff done around the house and some time with the family, and it was awesome. We also got a new puppy, so life's just, we thrive on chaos. But anyway, today I had to kick off the new season or new year with these two gentlemen that I have on today's show. I met them back in, I want to say it was November, when I was speaking at the PMRE conference in Las Vegas. They also were there speaking because they had a booth because they have this really great app called RightsClick. And the two guests that I have today, David Neuhoff and Steve Tepp, they both are advocates for photographers and creatives to be able to, copyright and stand up for themselves with their property, with their intellectual property. And so that's where all of their insight is, and all of their knowledge for their app comes from. So David has a blog called The Illusion of More, and he has written over 1,000 articles for this blog that strongly endorses copyrights and questions the tech industry's assault on those rights. So I, as a creative and as an artist, had some questions, of course, for who owns the rights to photos and, interiors when we take pictures of these, and then what happens when somebody else uses these, and then where does AI come into play? So between David and Stephen, who has a extensive background in IP law and actually is a IP attorney, they both shared so many insights on today's episode that my mind is blown. As a creative, I don't use this side of my brain, and we need to, right? We need to protect ourselves. So thank God there's people like this out in the world that can help us to understand the legality of the works that we're producing so that we can protect ourselves. So today's conversation is not only about AI, we definitely talk about AI and where legislation is going in this new year to protect, creators that utilize AI in some capacity in their work, but also for interior designers that are taking photos. If you ever have hired a professional photographer, you might know a little bit about the contract that you had to sign and who owns the rights and the copyright and all of that, or maybe you don't. Like me, I knew enough to be dangerous, but I definitely didn't know half as much as what we talked about today. So today's conversation is, I think, a great way to kick off the new year, just so that you're in a better place as to what are your rights, where does AI fall into place with copyright, and what are you seeing out there in in this space, and what are you doing to protect yourself as a creator? That's what I want to know. If you want to let me know in the comments, it's just a topic that I think we need to explore more. So without further ado, here we go. Welcome, David and Stephen. Thank you so much for joining me today. I am so happy to have you guys on the podcast this year to kick us off. So thank you.
Thank you. Thank you
Jenna.
for having us.
You're my first time having two guests. So this so you're joining me from RightsClick, and we got to meet in Vegas last year at the end of the year at the PMRE conference. So would one of you like to tell me a little bit about first your background and also what RightsClick is? Stephen, maybe start with you.
Okay, great. I was going to offer David, but you go ahead. So we'll follow your lead. Sure. So my name is Stephen Tepp. I am a copyright lawyer. I've been practicing copyright law for about 25 years, including 11 plus years at the U.S. Copyright Office itself. And I have seen from that work both inside the Copyright Office and in the private sector, working with professional photographers and other creators, how quite candidly the copyright system is leaving independent creators behind. And so a few years ago, when David approached me and we had become friends through some of his work, when he approached me with an idea of trying to make the copyright system accessible to independent creators, I was on board. And that's what RightsClick is all about. David will get into some of the more specific information.
Thanks. So my name is David Newhoff. I am not a copyright attorney, but I have become somewhat expert in copyright law over the past decade or so. I come from a creator's background, predominantly video production and other media production that I did for well over 20 years, mostly out of the New York City market, working for all types of clients, you know, uh, international clients to small businesses. And about 12 years ago now, I started writing on behalf of copyright rights for creators, in particular, taking uh, uh, criticizing, shall we say, big tech's assault on copyright rights. And I write a blog called The Illusion of More that got started through an organization called Copyright Alliance, with whom I'm still friends and colleagues of those folks. And that's how I met people like Steve. If you were in the copyright community, you'd find it's pretty small. And among advocates and experts, it's even smaller. Um, and so, as Steve mentioned, it was a few years ago that we got to talking about why independent creators don't protect their copyright rights. And it really comes down to understanding and time. And so RightsClick was very much built around the idea of, can we make copyright management easier, and so easy that it's something you can build into your workflow without it disrupting that workflow, without you becoming an expert in copyright law to have to do it. And that's where it was born. And we've been at it for a little over 3 years since the day we wrote the first idea of a paper, but about 2 years and change since launch.
Very nice. Well, thank you for giving us your background and telling us a little bit about what your program does. I want to ask in a second the details for RightsClick and like how it helps creatives and photographers and everybody to actually copyright their works. But this is an AI podcast, so of course we have to talk about AI. And this right now is such a confusing space. What is protected, what's not protected, what do we need to go through, both as designers and just creators in general and small business owners. So would you, Stephen, maybe give us a high level of what is your app protecting and how does it work? Maybe David, maybe you guys chime in with whoever's better to answer these questions. And then, how can designers and photographers use it and what's it protecting?
All right, I'll go ahead and start, and then David will fill in what I leave out. So the first step to gaining access to the copyright system is registering your rights with the U.S. Copyright Office in the works you want to protect. Because while the law says copyright protection is automatic the moment it is fixed in a tangible medium of expression, in the words of the statute, that protection really is a bit of an illusion. Because unless you have registered with the Copyright Office, you can't go to court to enforce your rights, and some of the key enforcement remedies are not available. And perhaps the most important of those is called statutory damages, which means instead of having to prove how much you lost because of the infringement or how much the infringer gained because of their infringement, you can just say to the court, pick a number within the range in the law. And that range is $750 per infringed work up to as much as $150,000 per infringed work if the infringement was willful, if they knew what they were doing and did it anyway.
Mm-hmm. Mm-hmm.
And so if you're talking about infringement of even 10 photographs, for example, that's up to $1.5 million. Now, obviously, that's not awarded on a regular basis, but and most copyright cases don't ever go to court. The whole point is, first of all, if it does go to court, and sometimes it does, sometimes you've got a big corporate infringer that should have known better, and yeah, it's going to go to court. But for all the other ones that don't, when you just send them a letter, or your lawyer sends them a letter that says, hey, this was mine and you used it without permission, I'd like to settle this nicely, don't want to have to litigate. But if we do litigate, it's registered. So I could ask for up to $150,000 per work. So that's 1.5 million for 10 images. You have the attention of the person receiving that letter instantly.
Yeah. Mm-hmm.
On the other hand, if you don't register, that person gets a letter from you and they ask their lawyer, and their lawyer comes back to you and says, well, are the images registered? And you say, I never got around to it. And they say, oh, that's good. Have a nice day.
Yeah.
Because the reality is, yes, you can register later, but then you don't get the statutory damages if you registered after the infringement began.
Okay.
And the practicality of trying to go to court, because then they're going to just say, they're going to call your bluff and say, no, we're not paying.
Mm-hmm.
Or we'll give you, a token amount.
Yeah.
And you could go to court, but then you've got to prove your own damages, and they're probably going to be smaller.
Mm-hmm.
And you're going to spend more on legal fees than the case is worth. And they know that, so they're going to call your bluff.
Okay.
So what Steve is describing fundamentally is the legal backstop, right? Is if you produce hundreds of thousands of photographs, which many photographers do, right? Any one of those could be infringed. And as Steve mentioned, if 10 of them are infringed in your career, which is pretty likely, that can be very valuable to you, especially out of thousands. And so the idea of RightsClick, what it does is you're able to very quickly, we want people to very quickly, as soon as you finish work, get that stuff registered, because that's the first step in getting control, right? And so you've just finished a shoot, you've got 100 photographs you care about, you make a project out of those in RightsClick, you literally push a few buttons. It's really, really simple, straightforward questions. You assign data to those 100 photographs or several hundred at once, send them through our system for registration. We process with the Copyright Office. We take care of some of the annoying parts for photographers, like filling out spreadsheets and all this other stuff that the office requires. And then your database is just updated with your registration numbers, or first your case numbers as the case is being worked on, and then the registration numbers. And then what you're doing is you're simultaneously registering your works, but you're also building a database of those registrations as you go, which you can imagine for photographers is really key, because again, if you generate thousands in your career and somebody 5 years from now infringes one of those images, you got to scramble and figure out which registration number is assigned to that particular image. Photographers get this great advantage in that you can register up to 750 photographs in one application. That's cool. It's pretty good value. However, the other side of that is if you have a certificate, which they send you from the office, and you've got a list of 750 photographs, titles on that page, that's not a great way to go search for which photo is on which registration. So that's what I mean by a database. Where RightsClick, you say, okay, this photograph of this house that I took, I can go and find that registration number very quickly, call up the right certificate. But also within RightsClick, you might not want to go to litigation right away. As Steve mentioned, one of the advantages of registration is that you can settle, and a lot of cases do settle. So RightsClick has, for example, in it tools where you can send it your own notice from you. Say it's you, Jenna, and you can send a notice. You use my work, and this is the work you used, and it's registered, and it's a pre-formatted note for you. It just basically comes from you and says, I want you to stop using it. I want you to send me X amount of money. And you've started a process that took you just a matter of minutes
Mm-hmm.
that will probably get you a resolution. And even if you then have to go to a lawyer because you're going to step it up a notch, so to speak,
Yeah.
you've at least taken control of it beginning with you. And that's a lot better than what most people do, which is go out on the internet and say, oh my God, this just happened. What do I do?
Mm-hmm.
And now you're open on social media to all sorts of useless advice, not going to get you resolution on your infringements.
Yeah. Okay. This is amazing. And I know that you're primarily talking about photographers right now. Now, a lot of the listeners here are not just interior designers. There's a lot of creatives, a lot of people from manufacturing parts of our industry, as well as photographers. So thank you for giving us like the fundamental understanding of what the app does and like the process to go through, because I think a lot of us thought that, oh, well, it's my image. I own the rights to it. I'm just gonna like, if anybody uses it, that's it. Like I can just go fight that. But there is a process. Like you have to still do things. So thank you for clarifying that from the get-go. Now, as it pertains to interior designers, you mentioned earlier tangible medium of expression. And while this is not, we're not always taking the photos, though I have started taking my own photos of my work afterwards. What does that mean when it comes to interior designers and what we own in the photo? Or do we own anything in that photo?
Great question. So the two pieces that you have to have for copyrightable work are creative expression, and that expression is, as we said, fixed in a tangible medium. What is creative expression? In some cases, that's really easy. Photographs are almost per se automatically creative. A novel, almost certainly creative. Anything more than a couple of sentences, chances are you wrote an email this morning that's long enough to be copyrightable,
Okay.
even if there's no reason to register it because it's not going to have commercial value. What's not creative are things that are dictated by the function and the utility. So, for example, articles of clothing, they have to have, a shirt has to have a neckline for the head to pop through and the arms and sleeves, and that shape, no matter how clever or creative in the colloquial sense you think it might be, it was still dictated by function. And so the Copyright Office will not register that, courts will generally not protect it. In the context of interior design, what that means is, for example, a vase that holds flowers. The shape of it is not protectable because it has to have a bottom so it stands, it has to have sides so it will hold some water and whatever plant life you put in there, and it has to have a top so that the plants or flowers can stick out. A couch, the shape of a couch is not copyrightable. A painting could be copyrightable, but chances are you didn't paint that painting, so you're not the copyright owner.
Mm-hmm.
What could be copyrightable are the selection, arrangement, and coordination of those elements, even if the elements themselves, a vase, a table, a couch, are not copyrightable works, or to the extent they are, it's someone else's authorship. A couch is not copyrightable, but the design pattern in the fabric might be.
Okay.
The painting is likely copyrightable depending on when it was painted and all that sort of thing. So the selection, arrangement, coordination is known as a compilation copyright. And of course, it has to be fixed in a tangible medium. So if you just have it sitting there in the room, that's not fixed in a tangible medium. Someone could knock over that vase and then it's changed. So that's why you need a photo of it.
Okay.
And the photo would be protectable both as a copyrightable work in and of itself and constitute the fixation of the compilation of elements as per the interior designer's wishes.
One thing I would add to that, Steve mentioned a vase a moment ago, and an example I'll often use is, a vase serves a function, but you can imagine how a vase could stand alone as a sculpture, right? And that's one of the questions a court might look at if you were contesting something like that. They'd say, okay, we take away the part of this that has to have a certain shape to be a vase, but does it stand alone as a sculptural work, for example? And arguably that's possible, right? You can imagine like a bas relief on the outside of a vase, and you could say, well, that design in and of itself could theoretically be. And as Steve mentioned, textiles, right? There was a case where the court, essentially, I mean, really, really basic designs for cheerleader uniforms, and that's how the court looked at it. Imagine these as illustrations. Yes, they happen to be turned into cheerleader uniforms, but they could stand alone as flat 2D art as designs. That said, 2D art designs are often scrutinized by the Copyright Office for originality, much more than say photographs. At least so I've heard.
Okay.
from illustrators. I can't say that for certain, as me or as RightsClick that that's per se, but some illustrators have said, yeah, the Copyright Office sometimes questions whether or not a really, really simple. I'm not talking about a clear representational illustration or something like that, but something that's very abstract, and the simpler it gets, the more the Copyright Office might say, well, we're not sure if this is original enough.
Right. Okay. Like the banana taped to the wall type situation.
Yeah,
Okay, we won't detour.
You're right.
Okay.
No bananas taped to walls.
All right. So what you're saying is that the compilation, or like how it's arranged in the space, being entirely unique and from the designer's mind, that could potentially be copyrightable in the way that they've arranged it, if there's a photo that goes with it to prove it. Am I understanding that correctly for the designer?
So just to be really nitpicky, since that's my job as a lawyer.
Yep.
It doesn't need to be unique.
Okay.
It just needs to be creative. So, for example, if a designer in California and a designer in Florida laid out a living room in almost exactly the same way, but neither of them knew that the other did it, they both have copyright in their selection, arrangement, and coordination.
Okay. Okay.
So it doesn't need to be unique. It needs to be creative, just a sufficient number of elements. If there was one table and one chair, well, it's kind of hard to prove creativity. The Supreme Court said the threshold for creativity is a modicum of creative expression.
Okay.
How many, how many elements need to be in a modicum? No one knows. But there are certainly close calls in determining creativity, as David alluded. Okay. But as long as you've got, I'll say half a dozen, just as a ballpark number, you're likely going to be okay in terms of creativity. And then the photograph is not just proof; it's actually a requirement in the law.
Okay.
In fact, it's actually from the Constitution, which says copyright protects writings, and the Supreme Court said writings means it has to be physically written down. Extrapolate that to visual art, and it could be a painting, it could be an illustration, or it could be a photograph, but there has to be some fixation of it. It could, digital is fine. It doesn't have to be on paper, old-fashioned like that, but it has to be fixed in some way, not just, oh, it was that way and I remember it in my brain. Your brain does not count as fixation for purposes of the copyright law.
Okay, so it has to be captured at that moment of time in order for it to be copyrightable, I guess is the only word, right? Exactly. Okay, so we have to prove that it was there, this was the thing, and we have to show a tangible result. Now, when we do that, we've been talking heavily about the photographers that take the picture, and they're the ones getting the rights to that. where does the designer come in to play with that? Are we both?
So that's going to be a bit of a, there are two copyrights.
Okay.
And this happens a lot in copyright law. The photographer has the copyright in that photo because the designer may have set out all the elements, but the photographer decided from what angle to take the photo and what lighting and all those sorts of choices, which are copyrightable expression once they're fixed in a photograph.
Mhm.
So ideally, what you'll have is a contract or license in which both sides have agreed, okay, the designer created this compilation work and retains copyright to that, authorizes the photographer to take a photo and recognize, and the photographer will have copyright in the photo.
Okay.
And they each, and the photo constitutes both an independent copyrightable work as well as fixation of the compilation created by the designer. The last thing I want to mention here is, since we did allude to including works of other people, like a painting or a sculpted vase or vase, as David says, he's fancy.
So fancy.
The
I don't know if
it's
that's my
important
West Coast thing or what coming through.
Probably.
yeah, I'm from New Jersey. We say vase.
Yeah.
Let's not talk about what you say in New Jersey.
Yeah, right.
Kids might be listening.
This is a family show. Got it. It's important to remember, if you're reproducing somebody else's copyrightable work, you might need their permission to do that as well.
Okay.
Yeah, and notably on that, particularly in your line of work, you might you might go to register photographs, for example, of a room that has a painting in it. And when you go to do that, depending on if the painting is prominently part of the expression in the photograph, that's also what we call limit of claim in copyright. You need to actually disclaim that piece of the work because it's carrying a lot of the expression in the work, right? Or even some of the expression in the work. And you need to say, I didn't create this photograph as part of your registration, or painting rather, as part of your registration. That could also apply to something else in the room, like a sculpture, anything that would be protected by copyright that you yourself did not create. Is worth noting, and the office asks you to disclaim that, which is a subject that will come back when you ask about AI, because this is a show part about it.
How do you know what my next question was going to be?
No, I did want to just reemphasize. Yes, I see this all coming from a creative world, working together with people, get those agreements up front so that you both understand, or all three of you, whatever it is, understand who's going to own what. It's perfectly fine for a designer to hire a photographer and say, this is all going to be my work. This is a work for him, and you're going to be the photographer, and you sign those rights over to me. That's fine. But know it up front so that there are no unhappy surprises. Because everybody becomes unhappy when it's decided after the fact.
Yeah. Yep. So before we get into the AI stuff, just to wrap that part up, through RightsClick, can they do that? Can they have, like, here's was the designer, here was the photographer. Can they do multiple people?
It's called, so what RightsClick certainly supports is what's called joint authorship. And so it doesn't, it's not necessary per se. Well, it is in that sense, but let's say you have joint authorship in a group of photographs. You can say, Jenna is one of the authors and Steve is another author. Probably won't be Steve doing the photography for you, but you know what I mean.
Okay.
Not if you want quality photography, but anyhow.
Okay.
let's say, Jenna, if you're the designer and David were the photographer, and you had an agreement where you each retain rights of your respective works, Jenna, when you file your registration application through RightsClick, all you're going to do is focus on your creative contribution, the compilation work, And you don't even need to mention David because that's a different work with a different author. And if he wants to register that, that's up to him.
Okay.
Yeah.
Okay. All right, cool. I'm just trying to bring the two industries and communities together to understand a little bit more about what we do. You know, there's a lot, I see it in the Facebook groups where like my photographer did this and, you know, I didn't get rights to that. And somebody took my image and they're not crediting me. What do I do? So like, I see these things and I'm trying to nip them in the bud now.
And it is tough for us to generalize since it's clear that you're trying to do that, and it is difficult. You know, as Steve said, photography is per se protectable under copyright.
Sure.
Design of a room, lot of questions there.
Yep.
It's not per se fixed in a tangible medium just by, you know, is there enough creativity? Is there, it's its own thing. It's not as automatic as say a photograph. So it's a little tough to generalize in that regard. So every single case, well, who really contributed all the creativity to this final work is a case by case question.
Yep. Yep. That makes sense. I mean, this just, you know, the 20 minutes we've been talking brings so much clarity. I think that like we just didn't have already to the copyright space for a lot of designers and a lot of new designers too that are getting into this. So let's touch on AI now. So there's a lot that we could talk about, but let's say, we'll start with this. Let's say there is a photo, it was taken of a kitchen, and we forgot to put a vase of flowers on the island, and we wanted to do that. So we used a generative AI tool to insert that after the photo was taken. Is that copyrightable? What's the process for something like that?
Okay, here we go. So at the most basic, it's like anything else you didn't create. David talked about the limit of claim in a copyright registration application. The Copyright Office wants to know when you submit a registration application, what are you claiming is yours?
Okay.
And so the flip side of that is they ask you to tell them what is not yours.
Okay.
So at the most basic, if as the photographer or as the designer, you would say, this vase.
Oh, I thought it was vase.
We're just fancy now. You're rubbing off.
is disclaimed. In fact, you don't even have to be that specific. The Copyright Office will prompt you to say some visual aspect or some text aspect. It's that general. You don't have to itemize.
Okay.
Because it's not your authorship. The Copyright Office and at least one district court have said that anything that is generated purely by AI is not copyrightable because there's not a human author.
Okay.
Now, that's the far end of the spectrum. There is a tremendous amount of gray area as to how much human involvement is needed to cross that threshold into what is copyrightable, including potentially the prompts themselves that were used. And there is a pending case in a different instance where the person using the AI system used hundreds, if not thousands, of iterations of prompts until he got exactly the image he was looking for. And he's claiming, even though the AI is what generated that image, that the prompts were sufficiently creative that he deserves some copyright protection. Now, you can't get copyright just because you worked hard. That used to be an element in the copyright law that the courts have rejected. You can't say, well, I worked for days and days and weeks and months. Doesn't matter. What matters is creative expression by a human.
Okay.
And in the same way that, if I tell an AI system to produce a picture of a forest with a river running through it in under a full moon, the AI created the moon, the AI created the forest, the AI created the river, but I selected those elements. So just like the arrangement of a couch and a table and a vase and a painting might be a compilation copyright, it seems to me there's the potential for a compilation copyright by the user of a generative AI system. That has not been litigated. That has not been decided. So I'm kind of freelancing here. But there's a lot undecided in this space.
Okay.
So again, to what Steve was just saying, I'll repeat the case by case consideration. Even as we get guidance, that's still going to be a judgment call for potentially forever. However, back to your original example, just a couple of practical notes, right? So you've taken a photograph that was taken by a human photographer, but you've used generative AI to add a vase on a table, and um and that's a perfect example of a moment to disclaim, use the limit of claim. I would add, even though, yeah, the Copyright Office right now asks for a very general statement, in part that's because their form doesn't accommodate AI. They haven't got there yet. But there is an opportunity in the examiner's notes to expand on that a little bit. If it were me, I would probably write generative AI used to add vase on table or something like that.
Okay.
In part, now that's a judgment call, but the reason I say that is because, as I understand it, the Copyright Office is beginning to look at photographs and try to assess whether or not generative AI has been used to create too much of the photo. And for this reason, another practical thing to consider, if you are to register a photograph that's mixed AI and human authorship, right now those can only be registered as single works. There's no group registration for that. And one thing you definitely don't want to do is, if you've got a group of photographs, don't mix in one of those AI generated partials in with your group, because the Copyright Office might reject the whole group or delay that process, because they'll just stumble upon this and say, wait a minute, we see a mix here of AI and photography. Whether they're right or wrong, that's just something they're beginning to look at, and that could either delay or reject the group. So you don't want to mix those. Those are, right now anyway, limited to one-off single registrations on what's called a standard form. It's as Steve mentioned, this is very much an evolving doctrine, and that also applies to the Copyright Office administration of the entire process. They are also figuring it out.
Fun.
This starts to illustrate the particulars of why we created RightsClick, because in addition to the complexity and uncertainty of the law itself, what is creativity, fixation, how much is enough, there are literally thousands of pages of Copyright Office rules and regulations and guidances about the registration process and how to comply with it. And of course, if you don't register, as we said, you don't have really enforceable rights. In the case of AI, the Copyright Office published a special guidance about how to submit copyright registration applications for works that were generated, at least in part, with AI systems. That document is over 25 pages long. So clearly not written for the independent creator who's tight on time and is not already a copyright expert. The upshot is, unlike what they've done traditionally, the Copyright Office requires, by virtue of this guidance, any applicant to disclose the use of AI and then to describe what the human authorship is. And they say in this that you have to submit them individually. As David just said, you can't get the group registration option, which is just devastating for photographers given the volume of photographic production. That guidance has gotten a lot of criticism from every corner of the creative community, literally from individual photographers all the way up to the big movie studios. So the Copyright Office has said they're going to revise it sometime in 2025. We'll see when. We'll see what they say. For now, this is what we've got to live with.
However, the important distinction, though, I would make between generative AI and assistive AI, right? And by
Okay.
assistive, I would refer to I'm using AI to expedite a process I already used to do, right? So
Okay.
like burning and dodging, changing color values, things like that. And I've now got an AI that helps me do the same thing I used to do faster.
Yep. Okay.
I'm not going to say definitively that that's, not something to disclose. That's a judgment call for the creator. It is a distinction between that and using an AI to create some expression that I never created myself.
Okay.
Right?
Yeah. That's interesting because I just tested out Imagen. Am I saying it right? IMEGEN. Okay. So I tested that out when I was taking my photos of my office, and it applied like all the filters, like a Lightroom, like just very quickly, but it did all the work for me using AI. So is that what you're saying could potentially be like, it was AI. I didn't do the enhancements to the photos. It saved me time, but it is something I could have done. Is that what the difference between like the generative, this is a new picture, or I'm adding a new component to an existing picture versus the editing process using AI? Am I understanding correctly the two differences here?
It is a difference whether or not that constitutes a kind of AI assistance that's not that you don't have to disclose is an open question, I think, at the moment. um it's a tricky one, right? Because we've all used things like Photoshop and other tools where you can choose the simple path of just saying, change these values, and in one swoop it changes these basic values for you. And if you sent that in, who would ever know the difference, right? Or I could sit there and painstakingly, change my luminance and change all these different things one by one. Tough call to make at the moment. It is different. There's no question it's different than asking an AI to actually generate an image that wasn't there before, or to generate a stream or something else that didn't exist. Steve, I'm coming just this close to giving legal advice, so I'm going to stop now.
We'll wait and see how this pans out.
And I'll let Steve finish the thought because he doesn't like me to give legal advice.
Well, it's not so much me as the bar associations get a little picky about that. But
I'm not part of the bar association.
That's the point. You're not paying them dues. You didn't pass the bar exam. They're very touchy about that.
Is that all it is? I just have to pay them dues and I can do it.
Well, that's part of it. Anyway, what David's getting at is exactly right. And joking aside, David knows more copyright law than some people who are licensed lawyers and call themselves copyright lawyers, but that's a different conversation. If there's a dividing line that's got some clarity to it, it's between generative, where the AI created something that doesn't actually exist anywhere, and assistive, as David said, where you created the image and the AI is editing, tweaking, that sort of thing, adjusting the color, sharpening the image, lightening or darkening, that sort of thing. What's in that image actually exists. You're just editing.
Okay. Yep. And that's been around forever. I mean, that's how we just do our photos. We're just doing it faster now. So I guess if we're bringing all AI into the conversation, now we probably have to just look at all areas, right? Is that kind of what we're seeing? It's just.
Yes. Yeah. I mean, copyright can get metaphysical really fast.
Okay.
Right. If you want to,
especially in photography,
but not just photography. I mean, if you really want to deconstruct things, the painter doesn't paint. The paintbrush applies the paint. The paintbrush is a tool. The painter doesn't, or the writer doesn't write. The pen or the pencil or the keyboard is what, and they're just tools to. you can atomize any work into non-existence with that sort of reasoning. Obviously, that's not what anybody does. That would be pointless. The question becomes, how far afield, how much variation, how much randomness is there between what the human indicated and what actually appears in a fixed form? So if I type the letter W on my keyboard, the letter W is going to show up on my screen. If I dip my brush in red paint and spread that across the canvas, that's what's going to be on the canvas. It's very close to one for one, if not one for one. What I intended is what appears. When I type in prompts to an AI, as you know better than us, Jenna, there's a randomness element. With the same prompts in the same system over and over and over, you're going to get different images, maybe subtly, maybe dramatically. The degree of randomness is the distance between the human authorship and non-human authorship.
Okay.
And that's why there's no absolute yes or no answer as to when copyright applies, because it's case by case sliding scale. How close was the output to what the human indicated?
Okay. There's one component that we haven't talked about that kind of piggybacks on what you just mentioned, and that is the prompting part of this, where you have the ability to take a stylized photo or a source photo and also upload that into a lot of these programs, right? So you can use an image as inspiration and then use words to like change that image and make it look different. For me, one of the ethical guidelines that that I teach and that I live by is that I never use another artist's art. I never take another designer's work. I don't use other people's photography. I never do it. It's just I use mine, or I create my own AI generated prompts using ChatGPT to create the images that I want to run through, and then I'll use those. So because I know how generative AI is random, but if you have a source image, it will probably come out looking very similar to that source image. And technically that's not your intellectual property. That's another designer's work. And it's such a close call that I would never want to take credit for something that is not mine. So for me, that's something that I do. I don't know exactly where I was going with this, but what do you think? Do you think that that is something that designers and people should be like doing for themselves, or how do they protect themselves, I guess, with this too? It's kind of a double question. Sorry.
Multiple. First of all, good for you for drawing that ethical line, and it's good to hear when artists do that, not only in their own media, but also it would be great to see when they're using the works that they don't make. For example, visual artists might respect their own medium, their own craft, but then they'll happily use music or narration or something else, forgetting that there are artists in another category of works that they might be using. So I'm glad you're drawing those ethical lines. Would love to see more artists do that, and which is not to suggest that there aren't. To to your, I guess, how would you when you say how do artists protect themselves? That was sort of your second question.
Yeah, against AI use, I guess.
Well, right now, unfortunately, that's a big question, right? There are about 30 lawsuits right now against AI companies for scraping volumes and volumes of work. The answer to that is we'll see. I'll let Steve chime in with details, but I mean, it's a big question right now. Does that constitute mass copyright infringement? And even if it does constitute mass copyright infringement, then how does that get resolved? And there are different theories about that. Everything from cynically saying it doesn't matter, these guys are so huge they're going to lose, and they're still going to behave this way, to licensing regimes, to different approaches. But how you protect yourself against scraping or something like that, there are a lot of theories out there. There's glaze, and there's other products about how to kind of poison your material. So if it's absorbed by AIs, then maybe it'll kind of foul the system. Alternatively, there may be business changes that come along that people don't anticipate. Sometimes tech companies get very excited about how something's going to go. And I remind you of Google Glass and how well that went. Sometimes
Yep.
they don't work out exactly like the plan. But on that topic, Steve, what would you add as far as the
Well,
protections?
yeah, I mean, look, there's a lot. I want to stay with what's practical because we could spend hours and hours talking about
Yeah.
big theory and for sure, many of the large language model generative AI systems were built by copying, scraping millions, if not billions, of works off the internet, many of which were copyrightable, and the copyright owner didn't even know, much less give permission, much less get paid.
Yeah.
And as David said, there's a lot of litigation about that, and there's a lot of ethical questions about that that go hand in hand. At the same time, creators, professional creators, understand that these AI tools are time savers. To not use them out of spite because they don't like how they were built is only going to hurt themselves more. And so they are using them. And you're one of the leaders on that. Uh, there are a lot of people using them in a lot of different ways. So your very practical question is, how does a professional creator, interior designer, photographer, any creator, uh, use these tools in a way that sustains their business? And how can they protect themselves? When you describe uploading your own works to sort of self-train the AI, and then you type in prompts, but then there's a degree of randomness from the AI, it's a little bit of creativity lasagna. You've got different layers, some of which are yours, some of which are the AI, some of which are mixed. And the courts haven't figured this out yet. I mean, they're still trying to figure out with just a basic photograph,
Yeah.
how much do you need to do from the human perspective and how much can be AI? Where do we land on that scale to decide what's copyrightable? When you start doing these layers and layers, that's additional sophistication and complexity that people haven't figured out yet. The best guideline I can give is the more that the final result is from demonstrable human direction, the more likely you are to be able to sustain a claim of copyright in that, either in the individual elements themselves or in the selection and arrangement, as we've been talking about.
Yeah. On
And
that topic, I'm sorry, go ahead.
no, go ahead.
On that subject, for people like yourself who are using AI to generate part of your work, want to understand whether or not you have authorship in that work, the case right now to watch is called Allen v. Perlmutter.
Okay.
That's isn't it, Allen?
Yeah.
Yeah,
He's
it is.
the one with the prompts.
Yeah.
Okay. That's the
So
prompt one? Okay.
there's another very important Allen case, but that's a different matter altogether. So, and that's the one to watch at the moment because that's the probably the best claim to date that says, look, I show a lot of creativity in the prompts that I've used to make choices to result in the image that I had in mind. That arguably is a claim of copyright, right?
Yep.
Not all that different from a photographer in a studio saying, let's move this model over here and let's do this and let's add, some shading here and all the choices you might make, and then tell the assistant, okay, push the button now. Very similar kind of, analogous to what this guy is saying as far as the way he used prompts. As Steve mentioned, how many prompts he generated, how hard he worked, that doesn't count. But what counts is, did he direct the system to produce an image that he had in mind? And can he make a claim for that? And that's the one to watch at the moment as far as, where we might be in terms of authorship, claiming copyright in a work that was generated by AI.
Yeah.
You don't have to read every word of the opinion, but that'll be the first one that comes out. I think that really answers, at least the first one out of the gate to answer that question.
Yeah. Yeah, we're going to see a lot of firsts this year, I have a feeling, with all these. Okay, this has been absolutely amazing. So for our audience, this is the second time we've shot this, because the first one we had some technical issues. So thank you guys for coming back and doing it again. In both conversations, I learned so much. Where can they find you if anybody had follow-up questions besides the app that we're going to link?
Thank you. David and/or Stephen at RightsClick.com.
Great. Excellent. So I'm going to link all that in the bottom too, so people can start using the app as well and tell their photographers about it for the interior designers here. Then their photographers might not know. Yep. Stephen, did you want to say something else? I'm so sorry. I didn't mean to cut you.
No, not at all. I just, one substantive point I wanted to make, because it's come up a couple of times, and it's not AI specific, it's more general, but it's a common misunderstanding. You talked in a number of cases about credit for the work. And as a business matter, as a promotion matter, obviously that's critically important to any creator. Copyright law, for the most part, doesn't care. If you copy somebody else's work and give credit for it, then good for you for giving credit. You're still a copyright infringer. It is
so go get permission from the original source and then do it and share, is what you're saying? Make sure you get permission first? Okay.
People think that credit excuses copyright infringement.
Yeah, thank you for saying that. I appreciate it.
And it does not.
Yep. Yeah.
Also, and also the companion to that is, but I didn't make any money with the use. Also does not matter necessarily. I mean, it may matter in a litigation and the details, but infringement is infringement, even if it's not necessarily for a commercial purpose.
Important. Thank you. Because I know that there are some designers out there, or wannabe designers, that have notoriously always shared other people's work with either no credit or credit, but like not actually asking them. And that has just been a social media issue for a very long time. So it's a good way to end this episode, I think. Just, man, we learned a lot. Thank you guys. I really appreciate it. Is there anything else you want to leave us with for today, or we'll just come find you after?
Thank you, Jenna. Great talking to you again. And happy to come back as the situation evolves and give listeners an update.
I think it would be interesting at the end of the year to see what has happened, to have you guys back on.
Terrific.
Sure.
Thank you. A wonderful start to your new year.
Thank you. Thanks, everybody.
Bye-bye.
Thanks for listening to today's episode of the AI for Interior Designers podcast. Don't forget to subscribe to this channel and tune in next week for more AI tips for your design business. See you next time.